Okay, well, it looks like we have both counsel connected, so we'll go on the record in Manson Medical Center versus Barrett. This is case number 22-14014. If I could have counsel put your appearances on, starting with the plaintiff, please.
Good afternoon, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, P5.
Looks like counsel, looks like you're muted. Or maybe don't have your microphone connected.
Can Your Honor hear me now?
Yeah, I think maybe it's your microphone isn't connected.
I'm going to restart.
Mr. Barrett, are you able to hear me?
I am, Your Honor. Good afternoon.
All right, Mr. Barrett, are you able to hear me?
I am, Your Honor.
Okay, great. Thank you. I think the opposing counsel is going to reconnect here, so just 1 second.
Can Your Honor hear me now?
Okay, yes. All right. So we've got everybody. So again, we're on the record. If counsel can put your appearances on, please.
Good afternoon, Your Honor. Christopher Sosson, spelled S-O-S-S-O-N-G, P59383, appearing from Vela Law Office on behalf of the plaintiff.
Paul Bear, B-A-R-E, 26843 on behalf of the defendant.
Okay, Mr. Sosson, this is your motion for summary disposition set for hearing today. I did have a chance to review your motion and the supporting documents. Mr. Bear, I did receive your response as well. So I'm familiar with the arguments of the parties. Mr. Sosson, anything further that you wanted to state by way of oral argument here this afternoon?
Yes, Your Honor. Thank you. Just briefly. I would note as well for the record that plaintiff did supply a supplemental exhibit in support of the motion for summary disposition, and that is the affidavit of plaintiff's agent in support of plaintiff's motion for summary disposition. Your Honor, this is a very fairly simple claim for the recovery of a balance owing for medical services that were provided and rendered to the defendant on 2 dates of service, January 5, 2022 and February 22 of 2022. Defendant did file a response in opposition to the motion for summary disposition. And there is agreement, Your Honor, amongst both parties as to the following factual points. First, there was a valid contract between both parties. All parties consent and agree that the plaintiff and the defendant entered into a contract, an agreement for plaintiff to provide and render medical services to the defendant in exchange for payment. And in fact, those consents to treat, Your Honor, and agreements to be financially responsible for payment are attached in support of plaintiff's motion for summary disposition in attached exhibit number 1. All parties agree on that. The defendant sets forth that agreement in the defendant's response to plaintiff's motion. 2, the defendant also agrees that plaintiff provided services in a competent and professional manner, and the defendant is satisfied with the quality of those services. Thus, Your Honor, we have performance. There's no issue as it relates to, did plaintiff perform on the contract, the agreement between the parties to provide the defendant with the medical services the defendant contracted to receive. That's undisputed. All parties agree plaintiff did. Further, as set forth in the defendant's response, the defendant states that plaintiff is entitled to reasonable compensation pursuant to the contract and in order to avoid unjust enrichment of the defendant. All parties agree as well that plaintiff is entitled to be compensated as contracted for the services that are provided and rendered. Defendant's response really only raises an issue, Your Honor, as it relates to 2 particular costs that were billed to the defendant. The amount being the first cost is a dispute as it relates to the penile implant reservoir being billed at $5,390.63 and a prosthesis penile inflatable OD that was billed at $21,103.13. The defendant, in the defendant's response, raises only those 2 costs, those 2 charges, as the issue here, and argues that those amounts there's a question as to whether they're reasonable amounts. As to all of the other charges as set forth in the invoices, the defendant does not take any exception to and does not dispute the reasonableness of everything else that was billed. So in viewing the defendant's response, Your Honor, it appears that the only amount in contest here is $26,493.76. Plaintiff is seeking complaint damages totaling $40,415.16. So by my calculation, $13,921.40 is not in dispute. Now, that being said, Your Honor, it is plaintiff's position as set forth in the affidavit of its agent that the charges that were billed to the defendant for the services and the parts were reasonable and customary and comply with industry standards. And that's set forth in paragraph number 5 of plaintiff's agent's affidavit. As such, Your Honor, it is plaintiff's position and contention that the charges as set forth in its invoice are reasonable, customary, and as such were billed to the defendant after plaintiff rendered services to the defendant. Now, the defendant has filed a response, but has proffered no documentary evidence to oppose why plaintiff's charges are not reasonable. There's no supporting documentation attached in support of defendant's response that would support any argument that the charges for these 2 particular devices or parts were unreasonable. The only documentation attached to the defendant's written response is the defendant's affidavit, wherein the defendant simply states in paragraph 8 that he expected to receive a bill of $15,000 to $20,000 based on what information he had available. But again, there's no documentary evidence that would suggest or show or reflect that the charges by plaintiff were unreasonable or not customary with industry standards. We have no report from an expert witness that would support defendant's contention that the charges were unreasonable or not customary with industry standards for providers who provide the same or similar service in the area. In fact, there's no other documentary evidence that would support the defendant's contention or claim that the charge is unreasonable. Defendant simply states that and questions whether the charge is unreasonable simply because of the amount of the charge. And that, Your Honor, is from plaintiff's perspective, is factually baseless. So, Your Honor, it is plaintiff's position that it's well supported its motion for summary disposition with documentary evidence in support. All parties agree, and as the contract sets forth, defendant was obligated to pay plaintiff for the services rendered. All parties agree services were rendered. There's no contention or dispute there. So it is plaintiff's position, Your Honor, that it's well supported its motion. It would respectfully request that the court grant the motion for the relief requested, or, Your Honor, in the alternative, either grant plaintiff summary disposition on the issue of liability and partial summary disposition on the amount of damages that are not in dispute, which is $13,921.40, and or set a hearing for the issue of damages as it relates to the two amounts that are in dispute. Thank you, Your Honor.
All right, thank you. Mr. Barrett?
Yes, Your Honor. Good afternoon. Plaintiff's counsel has done a very good job of setting out the parameters of the case. From the beginning on this case, the defendant has never criticized the hospital services. They did the job they were paid to do. He's been happy with the results. He simply, when he saw the bill, this did not seem to be what he expected based on the research he'd done. So it comes down to these two items, which are expensive items. The plaintiff has simply declined to give me that information, counsel for the defendant. I don't know why. I think it's certainly not a fishing expedition. I just want to know what the hospital paid for these two items, and just a simple consideration argument. I think as long as the hospital is asking for a compensation for this item, their bill is justified. They can show that they paid a significant amount for these items compared to the charge. If, on the other hand, they paid substantially less than the charge, as a medical facility, I would argue that is per se not fair. It's not just not proper compensation. As to counsel's suggestion of a damage hearing with partial summary judgment, I agree with opposing counsel that there is no dispute as to approximately $14,000 balance of the bill. And quite honestly, Your Honor, I hadn't thought about it quite that way. It's an interesting suggestion that what this comes down to is a damage. What are reasonable damages? If we know what the cost of the two items were to the hospital, I think we're good to go with that. The court could determine what reasonable damages are. So I would have no objection to that. And then the court could determine what reasonable damages are. And I do a jury in this case. If we go that route, we would waive the jury demand. We would allow the court to make a decision on the property.
Okay, all right, thank you. Mr. Sassung, any response to that argument?
Yes, Your Honor, just a brief rebuttal. First of all, I did have the opportunity to speak with counsel prior to the hearing. I notified counsel that we had never received or been served with counsel's motion to extend discovery. Counsel acknowledged that motion was served by email, was never served by hard copy. So we never had an opportunity to appear at that hearing to object to the defendant's request to extend discovery. Number two, there has been no discovery, despite that hearing that occurred apparently on October 3rd of to plaintiff for the information that the defendant seeks to obtain. There have been no discovery requests served to date as it relates to this information that is being sought. So, Your Honor, there are no outstanding discovery requests. So it's just plaintiff's position, Your Honor, that the defendant has the burden here to show that the charges are unreasonable. And it's plaintiff's position, Your Honor, respectfully, that the defendant's not presented any documentary evidence that would suggest, confirm that the charges as set forth by plaintiff in its invoice are in any way unreasonable. And as such, Your Honor, plaintiff would respectfully request the court grant the motion for the relief requested, or in the alternative, grant partial summary disposition.
Okay, thank you. Again, I did have a chance to review the submissions of the parties, the written submissions. Our oral arguments here today on the record have been consistent with the parties' arguments in their written submissions. I've also had a chance to look through the file, familiarize myself with the procedural history of the case. The plaintiffs have made this motion pursuant to 2.116C9 and C10, arguing that there isn't a valid defense and that there's no question of fact that the plaintiffs are entitled to the relief in the amount that they're seeking. Plaintiffs set forth the appropriate standard of review in their brief, and the court would adopt that as the standard of review that it is employing here in analyzing the motion. And of course, the court is required under any motion for summary disposition to view the facts in the light most favorable to the non-moving party, in this case, the defendant. I agree with both counsel. I mean, I think the issue really comes down to these two pieces of equipment and the charges for those, and whether or not there's a requirement of reasonableness in terms of the charges of those things. The court looks first at the contractual agreement between the parties, and I did review the exhibit, the releases provided by the defendant, which do outline that the defendant is accepting responsibility for any amounts that are not payable by insurance or any type of collateral source. And the plain language of that agreement doesn't state any terms of reasonableness. It doesn't state any terms that the charges have to be, standard charges or customary charges or anything. It's fairly broad language in the agreement. So when the defendant was accepting the services of the plaintiff here, the defendant was doing so under a pretty broad agreement to pay the costs associated with the goods and services provided by the plaintiff. So there isn't anything in the express language that would require the court to review this or the charges for those two pieces of equipment for reasonableness. So then the question is there an equitable basis to do that? Should the court imply a term of reasonableness in there? And perhaps the court should. The defendant didn't cite any law in support of their argument of reasonableness. No cases that directly apply to this situation to show that previous courts have applied a standard of reasonableness, or that any appellate court in Michigan has required or authorized courts to apply a standard of reasonableness under these particular circumstances. Certainly no statutory or other authority. So that the court doesn't have anything submitted by the defendant to rely on in terms of the authority for it to imply a standard of reasonableness in the absence of express contractual language. In terms of, if the court were to imply some type of equitable standard here or a standard of reasonableness, then I agree an appropriate analysis might be, what are the typical charges? What did the plaintiff pay for these devices, which it's then charging the defendant for? This case was filed about a year ago, a little over a year ago, October of 2022. The court issued its first pretrial order setting aside 90 days for discovery in February of this year. And regardless of the motion, which most recently happened to extend discovery, defense has had more than adequate time to submit discovery requests for that type of information, and it hasn't taken place. And so in terms of providing any kind of documentary or other evidence to support its argument under the court rules, under 2.116, the court finds that hasn't been done, and that certainly the defense had a reasonable opportunity to seek that information to the extent it wasn't provided, to compel through the rules of discovery the plaintiff to provide that information, and that hasn't happened. So at this point, the court finds that the plaintiff is entitled to summary disposition pursuant to C9 and C10, that the defendant has failed to state a valid defense as to those particular items, and that there is no question of fact as to the amounts. So the court will grant that motion. Mr. Sassong, the court would request that you prepare an order that reflects the ruling of the court today and submit that either with a stipulation as to form or under the 7-day rule.
Absolutely, Your Honor. A proposed order was submitted along with the filing of the motion for summary disposition. I don't know if the court has that in the file. If not, I'd be happy to submit one via 7-day or via stipulation.
I did not see a proposed order, so yes, if you would submit that, I would appreciate it.
Absolutely, Your Honor. I will do that.
All right, and then in light of the court's ruling today, the court is not going to proceed with the status conference because I think that resolves the claims in this case. And that's all I have for this afternoon. Thank you to both counsel, and both parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, counsel.
Thank you.
Okay, and Mr. Isles, I can take your case.
I'll go grab mine.
Okay, perfect.
Very small.
Okay, we'll go on the record in Burke versus Secretary of State. This is case number 2314299. Council can put their appearances on the record.
Ryan Ziegler on behalf of the people, Your Honor.
Scott Isles on behalf of the defendant, Your Honor.
Thank you. This is Ms. Burke's petition for hardship exemption for first applied consent, suspension of her driver's license. I did have a chance to review her written submission. And Mr. Isles, you guys can be seated. Thank you. Mr. Isles, I typically don't take sworn testimony for these hearings, but if you wanted to question your client on the issue of the undue burden,
Thank you.
happy to hear what she has to say.
You don't mind if I use leading questions, Your Honor?
Nope, not at all.
Ms. Burke, you are the petitioner in this matter.
Yes,
Speak up so it can be recorded.
yes,
And you live in Kalkaska County, but out past Manistee Lake, is it right?
right on, well, across straight from Manistee Lake.
And you earn your living as a house cleaner?
Yes,
So you have to go from point A to point B one day, and then next day it's point C to point J, is that correct?
in multiple places in one day.
And therefore, public transportation simply won't work?
Correct.
And you need to do that in order to pay your bills.
Correct.
All right, Ms. Burke, were you charged here in Kalkaska County as a result of this incident?
Yes.
Okay, what's the status of your criminal case right now?
Your Honor, she pled and was sentenced yesterday to an impaired driving to fines and costs.
Okay,
So it's
no,
been
no
resolved.
probation.
No probation.
All right, thank you. Mr. Ziegler, did the people take any position?
Your Honor, I think given the respondent's line or petitioner's line of employment, I do believe that would present a particular hardship for her. Public transportation, even though it's fairly hard to come by out there, wouldn't be appropriate to meet her needs. So I think she does qualify as having a legitimate hardship, whereas the court could take some action.
All right, Ms. Burke. Again, as you're aware, I'm sure Mr. Isles has told you, the court has to find that this would present some type of undue burden or hardship on you. Typically, I don't view problems with employment based on a suspension as an undue hardship. If you refuse a roadside testing and your license is suspended, that's just kind of the price that people pay generally. Problems with employment, getting to events and so forth is kind of the natural result of that. For the court to find it's an undue burden or hardship, the court has to find there's something particular about that person's employment that is different than regular employment or the hardships that would come with that with any other job. Because your employment does require you to travel between different locations, as opposed to just getting to and from a central location every day, the court finds that does present a different situation than in the typical circumstances, and a hardship for you that's over and above what would typically be present. Also, the court finds significant the fact that you've already admitted responsibility and been sentenced on that to fines and costs. So that part of the case has already been resolved. So the court finds that to be an additional justification for allowing an exemption. So the court will grant your request to the extent that it would be a restricted license. So that would only allow you to drive to and from and in the course of your employment, as well as any other type of educational or medical needs, and that would all be spelled out in that order. It's important for you to understand, and I'm sure Mr. Isles will explain this to you as well, that once you do get that restricted license, it's important for you to keep proof of where you're going, so that if you are pulled over for some reason, the police officer is going to want to know whether you have proof that you're driving within the course of your employment. Okay. So Mr. Isles, do you have an order now? Or
I do not. I'll have to draft it, Your Honor.
Okay, so if you submit that, the court will sign that once it's submitted.
Thank you, Your Honor.
For tonight,
No, Your Honor.
Mr. Ziegler.
No, Your Honor.
Okay, that's all for today. The 2:15 hearing was taken off the docket, so our next hearing is at 2:30. The court will be in recess until that time. Ms. Hartcup, are you able to hear me okay?
Yes, very, very well. Thank you, sir.
Okay, we'll go on the record in Michigan United Credit Union versus Huffman. This is case number 2314145. And counsel, if I could just have you put your appearance on the record, please.
Sure, Judge. Good afternoon. My name is Catherine Hartkopp, and I'm appearing on behalf of the plaintiff.
Okay, this is the date and time set for entry of a default judgment. And I've had a chance to review the file as well as your motion in support of the default judgment. Is there anything that you wanted to state for the record in support of that here today?
Really nothing further. I think it's a more comprehensive motion that lays out all of the requirements under Michigan Court Rule 2.603B. So unless the court has any other questions, I don't necessarily have anything to add at this time.
Okay, no questions. Just for the record, the court has reviewed the file. The court finds that plaintiff did take all the proper services or all the proper steps to try to serve the defendant in this case, that the defendant was properly defaulted by the court previously. And the court would note for the record as well that this hearing was set for 2:30. It's now 2:35 by my clock, and no one else has appeared on this case. In reviewing the judgment, the court finds that it would be appropriate to enter that at this time. There was a proposed judgment that was submitted along with the motion. Did you want me to just go ahead and sign that one?
That'd be great, Judge. There was a proposed judgment and a proposed order. So yes, if the court wishes to sign both of those, that would be great. I'll tell you, just kind of incidentally, we are noticing that many courts like the addition of the order to that packet. Some courts just like the judgment, but we and don't need the order, but we always try to include that order now just in case. So it's the actual order on the granting of the motion. So thank you, Judge.
Okay, I've signed both of those. Is there anything else that you wanted to address for the record today?
Not at this time, Judge.
Okay, thank you. That's all for today, and you're free to disconnect.
Great. Thank you, sir, and have a great day.
Thank you. trying to connect, but they aren't connecting. Just take a peek at that next file with Bishop. For sure. Thank you. Hello, is anybody there? Mr. O'Donnell, are you connected? Okay, well, I'm going to go on the record in O'Donnell versus O'Donnell. This is case number 2314223. So set for hearing at 2:45. For the record, had attempts by two devices labeled under Mr. O'Donnell's name to connect here. Both of them are joined the meeting, but for whatever reason, it may be a connectivity issue. Mr. O'Donnell's not able to communicate with the court. So the court is going to adjourn the hearing for today. The court will set this as an in-person hearing for next month in December. And the court will send notices to both sides to appear in person in the courtroom. So hopefully we can go forward then. Okay, looks like we have both counsel connected. We'll go on the record in Bishop versus Cecil, case number 2314275. If I could have both counsel put your appearances on, starting with plaintiff.
Yes, Your Honor. Jeffrey Allant, on behalf of Kathy Bishop, plaintiff, Your Honor.
And Abigail Bosco on behalf of Defendant General and Matrix Evolutions.
Okay, thank you. We're on the record here today for purposes of a scheduling conference in this matter. So just to kind of check in to see where things are at. It looks like we just had a recent stipulation. Mr. Allant, can you tell me where things are at from your standpoint?
Yes, Your Honor. I think it would be best, we have a mediation scheduled. I think that it would be best to have the pretrial after the mediation to see whether or not we come to a mediation agreement. And then, we would have the pretrial, it would set forth, discovery and, all the standard, summary dispositions if they're gonna be, all that timing. I think at this point, having a scheduling order would be kind of we don't know where we're gonna be. After
Sure.
That's just my feeling, Your Honor. And defendant might have a different view, but
All right, Ms. Bosco.
Judge, I tend to agree. I think, we're working on getting scheduled. We've reached out to CRS and just kind of waiting to hear back from, hoping to get it scheduled sometime in the next couple months. But I tend to agree. I don't think we'll really know if we're gonna, what kind of deadlines we're gonna need until mediation. So I think maybe if we could wait until that completed, probably would be the most efficient way to do it.
Your Honor,
Right,
I think it would behoove mediation if we could just have, like, the court has ordered mediation and that there'd be a deadline for it. And I mean, that would, get us a date and get it done. And then shortly thereafter, if it's not settled at mediation, we could have the pretrial then, kind of an adjourned or pretrial.
All right, I think we kind of already have that in place, just now that I'm looking at this stipulation that was signed on October 19th, which the court, that was incorporated into an order that the court signed.
Thank you.
So that's going to provide that the parties complete the mediation by end of January. And so what I'll do today is simply set this for a status conference at the court's next motion day following that period. And then that'll give us the time to check in and we'll see where we're at. But just looking at the claim and counterclaim here, I think what both of you are suggesting makes complete sense.
Yeah, thank you.
Okay. Mr. Allant, anything else I can address for your side today?
No, not at all. I appreciate the court's I appreciate the court.
Okay, thank you. Ms. Bosco?
No, nothing further from us. Thank you.
All right, the court will send out notice of date and time of that hearing. It should be sometime early February, and we'll go from there. All parties are free to disconnect. Thank you.
Thank you.
Thank you so much. Have a great day. Have a good Thanksgiving, Your Honor. Thank you.
Thank you. All right, sir, on the iPhone, are you Mr. Messner?
I am, yes.
Okay, thank you. I just wanted to make sure I had the right person. Okay, looks like we have council connected, so we'll go on the record in Messner versus Messner, and this is case number 2314266. If I could have council put your appearances on, starting with the plaintiff.
Good afternoon, Your Honor. Both on behalf of plaintiff, who's present via Zoom as well, Lindsay Messner.
Good afternoon, Your Honor. This is Matt Motley. I'm here on behalf of the defendant, Jake Messner, who's also present via Zoom with us today.
All right, thank you. We're on the record here today for purposes of a scheduling conference in this case to set some dates for going forward. So Ms. Pop, on behalf of plaintiff, from your standpoint, can you kind of tell me where things are at and what you would like to see in terms of scheduling?
Yes, Your Honor, we submitted a consent judgment of divorce. This was filed with the court on October 12th, and we are ready to proceed as a pro-con hearing today.
Oh, okay, very good. Mr. Motley, is that where your side is at as well?
Yes, Your Honor. If the court's so inclined to proceed, so are we.
Okay, absolutely. Thank you. All right. I'll take testimony first from Ms. Messner. So, ma'am, if you can unmute yourself, please. Can you raise your right hand? Here we go. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you. You can lower your hand, and Ms. Pop, please proceed with taking the proofs from your client.
Could you please state your full name for the record?
Lindsay Sue Messner.
And are you the plaintiff in this matter?
Yes.
Did you marry the defendant, Jacob Messner, on July 14, 2018 in Mackinac County, Michigan?
Yes.
Had you been a resident of Michigan for at least 180 days and a resident of Kalkaska County for at least 10 days immediately before filing the complaint?
Yes.
In that complaint, you stated that there had been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved. Is that still true today?
Yes.
Is there any way that you and the defendant could reconcile or preserve the marriage?
No.
Are you pregnant?
No.
Were there any minor children born during the marriage?
No.
And have you reached an out-of-court agreement pertaining to division of property?
Yes.
Is this agreement accurately reflected in the consent judgment of divorce that was filed with this court?
Yes.
And do you understand that the agreement on all property issues is final?
Yes.
Do you understand that there is no award of spousal support to either party and that that right of spousal support is waived?
Yes.
Do you believe that the judgment and its terms are fair and equitable?
Yes.
And you also had an opportunity to engage in extensive discovery regarding any and all issues in this case, but by entering into this and signing this consent judgment of divorce, you have elected not to do so. Do you understand that?
Yeah.
Do you understand that you had a right to trial in this case? And at the trial, the judge would have ruled more favorable, less favorable, or substantially similar to your ultimate settlement in this case?
Yes.
And are you asking that this court enter the judgment and in doing so, knowingly and voluntarily waive the right to a trial?
Yes.
Has anyone promised you anything in order to get you to sign this judgment or placed you under any sort of duress to agree to the judgment? Anything other than what's included in the four corners of that consent judgment of divorce?
No.
Are you satisfied with the efforts of your attorney in this matter?
Yes.
And do you have any questions for me or the judge?
No.
Thank you. I have no further questions, Your Honor.
Thank you. Mr. Motley, did you have any questions for Ms. Messner?
No. No, Your Honor.
All right. And did you want to take any testimony from your client today?
If this court's so inclined.
I don't think I need it. I think we've got the statutory proofs, but I always give counsel the option if there is anything that they need to take from their client.
Well, I can briefly go over it then with him, just so you have it for your record, Judge.
All right, Mr. Messner, if you can unmute yourself, please. Thank you. If you could raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand and please proceed, Mr. Motley.
All right, Mr. Messner, you guys understand that you guys entered into a consent judgment of divorce, meaning you and the defendant?
Yep.
Do you guys have any minor children in common?
No.
Do you have any reason to believe that plaintiff is pregnant at this time?
No.
And have you read the proposed consent judgment of divorce?
Yes.
Do you understand the terms?
Yep.
Do you agree with the terms?
Yes.
Do you believe that the division of property, including the assets and debts, was equitable?
Yep.
Do you understand that both parties are forever waiving spousal support, and absent fraud or duress, neither party may later return to this court and request spousal support?
Yep.
Do you understand you had a right to a trial for this matter, where you could call witnesses and otherwise present your case pursuant to your request for relief?
Yes.
And that this outcome could have been better, it could have been worse, or the same as the items agreed to in the consent judgment of divorce?
Yes.
And knowing all this, do you still wish to proceed with the proposed consent judgment of divorce?
Yes.
All right. Do you have any questions for myself for this court?
I do not, no.
All right. Well, I have nothing further, Your Honor.
Thank you. Ms. Pop, did you have any questions for Mr. Messner?
I do not.
Thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. I reviewed the proposed judgment and find that it's generally equitable and contains all the provisions required by statute. The court has signed that proposed judgment. Ms. Pop, anything further I can address for your side here today?
No, Your Honor, thank you.
Mr. Motley.
I have nothing further, Your Honor.
Thank you. That's all for today. All parties on this case are free to disconnect at this time.
All right. Thank you all.
Thank you.
I just got a message from Brian O'Donnell. I was just gonna tell him, let him know he's gonna be rescheduled in person.
Yeah,
Because the divorce.
you want to let him know. I tried to connect with him for 10 minutes, but I had to move on the docket.
Okay, it was Jen that called. Jen?
Oh, Jen.
Oh, yeah. Then let Jen know that.
Okay.
And let her know that we just need to reset it as an in-person hearing.
Okay.
Thank you. Okay, looks like we have everybody connected. We'll go on the record in Nellis versus Manson and Kalkaska. This is case number 21-13787. And if I could have counsel put your appearances on, starting with plaintiff.
Good afternoon, Your Honor. John Elliott on behalf of the Nellis.
Your Honor, Jim Elliott on behalf of the plaintiff.
Morning, Your Honor. Nick Artave on behalf of the Kalkaska defendants, Michael Bryan, E.L. Miller, and Ken Aylesworth.
And Your Honor, Gretchen Olson appearing on behalf of Manson Healthcare.
Okay. All right. So this is, we're set for a hearing today on plaintiff's motion to compel. I did have a chance to review the plaintiff's motion as well as the responses by the defendant. And so I'm familiar with, you know, kind of each side's position on this. Mr. Elliott, anything that you wanted to state in addition to what's in your brief and motion?
Yes, Judge, yes, because when we just received defendant Kalkaska's response, they also provided a supplement to some of the discovery that was part of this motion on the second. So that somewhat limits what we are requesting them to still supplement, however much is still needed. I do think it is worth addressing the response as well, because, you know, we were clearly misrepresented in this, and it's in a way I really take issue with. I'd like to share a screen. We were alleged to have demanded 5 days or 7 days after the hearing on the motion for summary disposition, the discovery. I have the letters. We were opening up the conversation saying we'd like to discuss how to proceed with discovery. After being ignored and not responded to at all for a week, we sent another letter on September 28th, also extremely cordial, indicating we'd like to address the issue of discovery without having to file a motion. If your honor cares to, I have them up and I can share the screen, but we're not demanding discovery. We try every time to work with the defendants and every time we have to file a motion. I would also.
Go ahead, I'm sorry.
I was going to say, your honor, I would also like to address where we actually are at in discovery, because I think it has been based, at least on Kalkaska's motion, conflated. On February 1st, this court entered an order that was after a hearing on January 4th that compelled responses to discovery plaintiff's second set of requests for production of documents. On the 4th, the Manson defendants acknowledged they had not responded. They had sent the completely wrong documents, and defendant Kalkaska's answers were deemed by the court and in the order minimally responsive and quite lacking. There were many arguments that day based on peer review and attorney-client privilege and work product. Those issues, the court indicated that while you had some hesitancy with the validity of the arguments by Kalkaska, they had not even answered enough for you to make that decision, and that they needed to supplement, and then you would let us file another motion if necessary. They supplemented by cutting and pasting the arguments that your honor had ruled on that motion and compelled, and already told them it was you had issue with and did not necessarily believe it was exactly as they were stating, and you were going to address it. We filed a motion to compel. At that point, they also filed a motion to limit discovery. Your honor held in abeyance at that point, in a limited scheduling order, the February 1st order. That limited scheduling order, which was signed on February 14th, specifically indicated as to the January 4th hearing and the order that followed that, which was a February 1st order, the hearing shall, the order regarding discovery shall be held in abeyance until immunity motions are heard and decided. There was no language that we were going to have to come back and decide other dates after the immunity decision was decided based on that order. The February 1st order went into effect on as soon as the other orders were decided, or the immunity issue was decided on September 15th. And that's the 214 order of this court. The last paragraph, it's called interim scheduling order. So the 410 order that is brought up in Kalkaska's response, it says plaintiff somehow was trying to hide that from putting it in our order. That had nothing to do with these motions. That had to do with whether or not another motion to compel had to do with governmental immunity. And your honor went through it and decided against plaintiffs in that case that the issues that we brought up in that motion did not have to do with governmental immunity. It had nothing to do with the second request for production of document supplementation that was addressed in the February 1st order. The two interrogatory sets were served after the motion to compel that was heard on January 4th. And those interrogatories are also at issue here and need to be supplemented. The fact that the defendant Kalkaska, it seemed like the first part of their response arguing that because they were making legal decisions about whether to appeal or whether they believed their clients were still in the case, despite the order that was eventually entered was exactly the court's words stating as such, that somehow alleviated them from having to proceed with the case. They were under an order from February 1st that was kicked into effect based on this February 14th order again, and also just requested politely and kindly by council to start talking about it on September 20th. Yet they have not addressed it. All that's still needed, and I'll read off the exact questions or requests under each defendant. The second request to produce from Kalkaska, we just need the reports and investigations about the incident. This is what Your Honor discussed at the very beginning on that, or not the very beginning of the case, but at the beginning of this discovery saga at the January 4th hearing. We want statements, whether written or oral, made by any person who witnessed or has knowledge of incidents, including the party. We want statements made by individuals, if they have them. We want the entire insurance claims file, which I would assume would also have incident reports in it as well, with the interrogatories. They supplemented on November 2nd. The one that still is needed is the interrogatory number 7, and this is from the 3rd set of interrogatories to the Kalkaska defendants. And number 7, they cut and paste that exact same response that they did to the other issues, and it's their peer review argument that now that we have it, we're going to have to address an emotion. The court's going to have to decide, I assume, this issue again, because they cut and paste the same argument they made in their response to our initial motion to compel that was heard on January 4th. This interrogatory had to do with members of their alleged peer review panel. This was because they had originally did the blanket peer review response in the request for production. And we want to find out who are the people or entities who are supposedly conducting this peer review that they are trying to hide everything about what happened at this incident in. Again, the arguments were made clear in our prior motion, and Your Honor already heard these. Peer review documents protection does not protect every document peer review looks at. It protects documents specifically requested by peer review and created by peer review. If someone writes an incident report, it doesn't become peer review protected just because later the peer review panel looks at it. So this, again, is a peer review issue. They're saying everything's peer review. We won't tell you what it is that's peer review. They won't even tell us if they have it. Just that there's something in peer review, and we don't know who it is. They still even here won't say who the people in the peer review are. We don't know who we can depose to find out what these are. We may need the court to conduct an in-camera review of these documents because they won't tell us, despite the court's order, what there is if it's even there. They're just saying peer review protects essentially anything if you want to know what happened. The other
Mr. Elliott, Mr. Elliott, 1 second. I don't want to, I want to give you an opportunity to tell me what you need to tell me, but I am up against some time limits here. I've got another 3:30 that's waiting, and then I have a 3:45 and a 4 o'clock. So if you can really just cut to the chase, tell me exactly what you're asking for. I can give the defendants a chance to respond and then make a ruling, but I got to move things along here this afternoon. We only had 15 minutes set aside for this hearing, so I apologize for cutting you.
No problem. I will speed it up. Interrogatories, the 4th set of interrogatories, we need question 2 and 3 supplemented or just answered truthfully. Again, the one in question 2, they are answering only one camera would have captured Mr. Nellis on the grounds there. It was requested every single camera that would have captured him or anywhere on the grounds, inside or outside. They say only one and that we have it. Yet in the next interrogatory number 3, they say the hall cameras may have captured him, but they've been overwritten. We need to know what cameras would have captured him. Where were they? We can see in the video there was another camera that was facing right at it. They just gave 2 inconsistent answers. We need them to give us information about the cameras in this case. With regard to defendant Manson, his order only requested for a response or supplementation to the second request for production of documents. not with respect to the interrogatories. And that was the second request of production that we needed supplementation of was request number 4, which again is the issue of the claims file. Again, it was a blanket work product objection, same as last time, same as we dealt with Kalkaska on the 4th. And also, I think that's only one interrogatory or a request 20 and 21. Manson indicates they don't know what documents they gave to defendants Bryan and Miller when they turned over our client to their care, and they also say they don't know who brought, what paramedics or individuals brought him to their hospital, I guess, apparently, on the 19th. But they're claiming they don't have that information, I guess. So the main one they need to supplement is the 4th, the claims file, as we requested. Other than that, the supplementation that was received on November 2nd with the filing of their response is all that's left at issue.
Okay, all right, thank you. Mr. Artev, on behalf of Kalkaska defendants.
Thank you, Your Honor. I'll try and keep my response brief here. Just in terms of the comments made by Mr. Elliott, in terms of the substance of our brief, I apologize if you took any offense to our characterization of the correspondence, and I would just say that, at the time of the motion that was filed, we were, just conducting certain correspondence and communications with our clients and determining whether an appeal is necessary. So with that being said, in terms of the supplemental responses that he is requesting, in terms of the second request for production, again, I think we stand by our brief, and I guess I might be missing something here, Your Honor, but I thought there was a motion to compel on those exact same requests for production filed in March. There was a hearing held on April 4th, and you denied that motion. But if I'm mistaken, please let me know, Your Honor, and we'll readdress the issue. In terms of the 3rd and 4th interrogatories, Your Honor, we've supplemented those responses as well in terms of the claim that, we're hiding something or there's something inconsistent. That's just not true. And second, Your Honor, a lot of these things are irrelevant to what's left in this case, and the only count remaining is whether there was negligence committed by the defendants here. The claims related to what cameras were present and whether they were discarded or somehow edited or altered, those are completely irrelevant to the case at issue and right now. As far as I recall, that particular count was dismissed by this court in the MSD. So, Your Honor, with that, I believe that we've supplemented our responses to the fullest extent at this point. In terms of our objections to the peer review, to the privilege, we stand by those objections. We think there's extremely strong case law that supports us not providing that information to plaintiff. And if he thinks otherwise, then we'd be happy to address that in a separate motion and make those arguments. But as far as we're aware, we've done substantial legal research. We provided substantial, legal justification for those responses and objections. And at this point, we haven't really heard any sort of legal basis from plaintiff to override those peer review privileges, which are pretty expansive and well documented in Michigan courts. Thank you.
Thank you. Ms. Olson?
Thank you, Your Honor. First, the plaintiff did object apparently to that we didn't answer the 4th set of interrogatories, and clearly per the court file, we answered them. So I'm not sure how that's part of the motion, and maybe they realized it after they filed the motion and they're not arguing it now. I don't know. But clearly we answered their 4th set of interrogatories. So that shouldn't have been part of their motion, and we shouldn't have to respond to it. As to the motion to the second request to produce, I give the court the same answer. the court's order was entered on February 1. On the 3rd, we provided supplemental answers. We answered as the court required us to do. If you don't have the documents, tell them you don't have the documents. That's what we did, Your Honor. So I don't, I don't know how they can object to something. If we don't have them, we can't produce anything. We're not going to go out and manufacture documents that we don't have. As to the claims file, I agree with counsel for Kalkaska. There is ample support for our answer in that regard. And Your Honor, we did supplement that answer as well. We told them that without waiving the objection, we had no statements, no photographs, no recordings. And the only photographs that exist are contained within plaintiff's medical records. So we provided him the information that he is seeking. He just doesn't apparently like the answer, and he keeps coming back to court to ask for something that we don't have. I think the claims file itself, the impressions of the adjusters, whomever, those are clearly protected by the work product privilege and by attorney-client privilege. So beyond that, Your Honor, we shouldn't be responding to this motion at all. And frankly, you know, I should request costs because of it. So I'll leave that to the court's discretion, but there is nothing we can produce if we don't have the documents.
All right, thank you. Mr. Elliott, brief response.
Sure, Your Honor, I will make a brief response. And also one thing I did need to address, we still have not received one single discovery response signed by a party or an agent of the party. Unless the attorneys signing them want to be deposed, we want all discovery answers signed by a party or an agent as required by the court rule. I would request that for the interrogatories. A very brief response. You know, again, the March hearing, and this is from Kalkaska. The March hearing was about governmental immunity. It was a hearing on a motion to compel, and our argument that certain limited of the issues that had been addressed at the in the February 1st order and the January 4th hearing did pertain to the issue of governmental immunity. It was not a motion on these issues. This issue is the motion that Your Honor at the hearing on January 4th said, see if they supplement, and if not, file a motion to compel if they don't provide the proper answers. And as to Manson, no, they did not supplement with regard to the claims file. It's just a whole big argument that it's not there. And the same thing that what we gave you that's not privileged is the medical records. There's a claims file. These entities are extremely close and intertwined. I would anticipate there are incident reports or some other reports that were not generated as impressions by an attorney in furtherance of his work or communications with a client, and that are subject to discovery. And if there's anything that these entities still believe are protected by one of these blanket privileges, I would ask that they provide them to this court for an in-camera review, because so far we don't know what is out there. We just know they're both telling us everything is protected by privilege, essentially, other than the medical records or what this court has compelled in the numerous motions we've had to pursue thus far to get discovery rolling. The matter is going forward on the negligence claim. The cameras was not a separate claim, as Kalkaska's counsel is indicating. The cameras will let us see what happened. Will let us see, did Mr. Nellis' head hit the ground? Did Mr. Nellis' body hit the ground? What happened when he was inside, where they say he didn't show any signs of distress, yet Mr. Ellsworth said 50 feet down the hall in his office he could hear him making noise, grunting and groaning, and had to come see him. Why my client had to sit for hours with 6 broken ribs and a punctured lung with no medical treatment. That all would have been shown on the cameras, and this issue is important because we're going to be making motions or arguments for spoliation of evidence if at some time at a jury trial. potentially. So we need to know what cameras were there is relevant to negligence. All of the discovery we're requesting is relevant and necessary. And I ask Your Honor to compel them to produce it.
Okay, all right, thank you. I've got the arguments of counsel on this issue. The court will issue a written order reflecting the extent to which, if any, the court is going to grant the motion to compel. Thank you, counsel. All counsel are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Still got one to go before we call those people in. Oh, no, hold on. Wait. Before we call those people in, I have one more hearing to do. And I only want to call one group in at a time, so.
The 3:45 and then the 4 o'clock.
Yeah, because I don't want a whole room full of trying to, everybody filing in and out, and, okay. Okay, we're on the record now in Dyka versus Dunn Construction. This is case number 22140116. If I could have both counsel put your appearances on the record, please.
Good afternoon, Your Honor. Abigail Bosco on behalf of Glenn and Samuel Dyka.
Good afternoon, Your Honor. Richard Batchel on behalf of the defendants.
All right, thank you. This is set for a status conference in this case today. So on behalf of the plaintiffs, Ms. Bosco, can you tell me where things are at and what we need to do in terms of scheduling going forward here?
Yeah, Judge. I mean, we've done discovery, we've done depositions, we attempted mediation unsuccessfully. I don't think there's much else left to do besides set this for trial.
Okay, Mr. Batchelor, would you agree with that?
Yeah, I mean, attempts at negotiations haven't been fruitful, and I think that's the next step.
All right. Then on behalf of the plaintiffs, Ms. Bosco, how much time do you need to be ready, or do you need to get ready for a trial in this case? In other words, how far out would you like the court to look for dates?
I would say looking at a couple months. So, you know, end of March, April, May, that area.
Okay, and how much time for trial do you think this case will take?
Is it bench or jury? I can't remember right now.
I believe it's a jury.
The jury to be made by Mr. Batchelor's clients.
So 2 to 3 days, probably.
Okay. In terms of those timeframes, Mr. Batchelor?
Yep, those are fine, Your Honor.
Okay. Mr. Batchelor, your side demanded the jury trial, is that correct?
Correct.
Okay. All right, so we'll set this for a 3-day jury trial. About 180 days out. And the court will set this for a trial preparation conference about 30 days prior to that trial date. When we have that, at that conference, the court will have an opportunity to discuss kind of trial procedure, exchange of final witness and exhibit lists, jury instructions, and so forth. To the extent that either side has any motions in limine, then they would need to be filed and set for hearing no later than the date of that trial prep conference. So any of those kind of pretrial motions that we need to address, I'd want to hear them on that date as well, so that we have all those things out of the way well in advance of the trial. And other than that, that's the only dates that I would set at this point. Ms. Bosco, are there any other dates that you would request?
I don't believe so, Judge.
Mr. Batchelder?
No, Your Honor. My client's insurance carrier did inquire as to whether there'd be a settlement conference, but if not, then I'll just let them know that.
No, that's not something I typically would schedule. So, no.
Okay, all right. No, nothing else then, Your Honor.
All right, so the court will send out notices for the trial dates as well as the trial preparation conference. Also send out a status conference order specifying, that trial prep conference is the cutoff date for any motions in limine. And we'll go from there. Thank you. Both counsel are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Judge.